So welcome everyone to Xtrategy's offices. We're really happy to have you here. We will continue with the second panel of today, which is called Developing In-House Defense Capacities by Sovereign States in Investment Arbitration and State-Owned Companies in International Commercial Arbitration. Today's moderator is José Antonio Rivas. Apart from being the co-founder of Washington Arbitration Week, José Antonio is also the founding partner of Xtrategy LLP. And he's an international lawyer and arbitrator with more than 18 years of experience. He has acted in ICSID, UNCITRAL, ICC, and GAA cases for sovereign, state-owned entities and private clients, co-founded Washington Arbitration Week and the World Arbitration Update. Previously, he served as Colombian Chief Investment Treaty Negotiator, Legal Counsel at ICSID, and a Senior Associate at Arnold & Porter. He teaches Investment Treaty Arbitration and Public International Law at Georgetown Law and holds Law and Economics degree from Universidad de los Andes. He is admitted in DC and Colombia and is a CR Fellow and member of ICSID, AAA, and SIAC panels. So with that, I give it to you, José Antonio.
Thank you, Maria, and thank you to everyone here. I mean, to tell you the truth, we're a little bit nervous because it's the first day. It's wonderful to see a high caliber panel. We're very lucky to have them, and it's also wonderful because we have high attendance today, so everything is good. As said by Maria, we're very happy to have you here at Xtrategy in Washington, D.C. And today's panel relates to a big question that many sovereign states and also state-owned enterprises have in international arbitration, both investor state and international commercial arbitration. And that big question is, how do I, as a state, I mean, thinking as a sovereign would think if it were a person, how do I prepare my in-house team to defend my disputes or the disputes that I have to defend against as a sovereign state or as a state-owned enterprise? And those cases could be investor state cases, or they could also be contract cases. We have seriously an incredible panel because this both or all of them, Mallory, David, María Carolina, Mijail, and Jean-Pierre, who are in Peru, have experience in investor state arbitration. They have experience defending states, some of it past experience, some of it current experience, and they have thought through these issues. So we couldn't be more lucky. I mean, of course, I constitute the panel, but anybody would have liked to have them. So I'm really happy that they're here. They accepted the invitation, and one thing that I always say is like, yes, they're well known in the international arbitration community, but I think that they well deserve being known by others that might not know them. So in that order of thinking, I would like to say that we have Mallory Silberman, who is among the world's most experienced young practitioners of investment arbitration, having presented investors in 17 states in about 50 cases, according to Lexology. She's a former Arnold & Porter partner, and her consultancy is MS, or Miss Arbitration. I know that she likes to play with words. Now provides bespoke advocacy training and helps sovereigns with capacity building. And I could keep on talking about Mallory, but she would kill me if I did. So now, next is María Carolina Durán, who is counsel at Baker Botts. She has extensive experience representing investors and states in complex and high-profile disputes. Her cases span the full range of economic sectors, including electricity, mining, oil and gas, and infrastructure, and cover the globe, with a particular emphasis Latin America. Notable successes include representing clients in various investor state arbitrations with a total of $59 billion in claims. She has been recognized as a rising star by Legal 500 and on to watch by Best Lawyer. So watch. Next is David. David Bigge is has served as Chief of Investment Arbitration at the Department of State since 2023 and has been at the department since 2010. His other roles have included U.S. agent to the Iran-U.S. Claims Tribunal, deputy agent in 2 cases at the ICJ, U.S. point of contact to the International Criminal Court, and working on UN affairs, including the 6th Committee and the ILC. He's also an adjunct professor at Georgetown, where he teaches a course on interstate disputes. And I must say that when he truly is a public international law lawyer. So if you look into what he has said, it's so what he has done. It's very interesting that all of that experience, he might be able to share this, also feeds into his practice in investor arbitration to some extent or to a great extent. Next, we have Jean-Pierre Galvan, who is the president of the Peruvian Commission for Investor State Disputes, and this is one of a kind commission, I must say, that exists in the world, and quite a successful commission. One thing that I didn't say yet, but I'm going to emphasize on this now, is we have 3 state officials, 1 from the U.S. and 2 from Peru, and the interesting part of having them 3 here is that they have, at least in my view, quite a successful investor state defense set of results. They have both nations have had successful defenses in big quantum cases, and I'm emphasizing that because they have completely different models of defense. One is fully in-house, which is the US's, as Canada's, or other nations, and the other one is the Peruvian model, which is highly institutionalized, but it is also a model that significantly relies on external counsel. But the fact that it relies on external counsel doesn't mean that everything is done by external counsel. There's a lot of managing the disputes. There's a lot of actions that are being done by the commission and by its president now, Jean-Pierre, and also by its secretary, who is our other speaker, Mijail Cienfuegos. But to be a very truthful, I would like to share his background. Jean-Pierre is a lawyer with over 14 years of experience in directing, assessing, and managing risk, as well as structuring PPP infrastructure projects, public services, and complex arbitration. He currently serves as president of Peru's Special Commission representing the state in international investment disputes with the Ministry of Economy and Finance. And last but not least is Mijail Cienfuegos, who is also a legal advisor and technical secretary of the Special Commission representing the state in the international investment disputes at the Ministry of Economy and Finance in Peru. Since 2019, Mijail has been involved in more than 30 cases as a government lawyer. So with that, I would like to welcome our speakers and ask first a question that some of you might not know the answer is how did the US's defense team grew up, and how was it created in terms of the panel? We see the results now. We see the results after Lowe, and we see the results in other cases today, and it's a high caliber team. But there was a time that it wasn't like that because it wasn't created. And I go back to my exit years. I saw a little bit of that, but I think you know way more than everyone here.
Sure. Well, first, thank you, Jose Antonio, for the very kind introductions, and thanks to Xtrategy for hosting and for all of your efforts in putting together this entire week of events, which is always amazing. I do have to say that I'm speaking in my personal capacity. I don't think I'll be actually saying anything terribly controversial today, but in any event, all of the views I'm expressing are my own and not necessarily the views of the U.S. government. The first question that comes to mind when sort of constructing the team is, where is it housed, in what agency? And what's very interesting is when you're working in this field, and particularly, for example, when I'm at UNCITRAL negotiations and I'm meeting my counterparts from other countries, it's really interesting the variety of backgrounds that we all bring. So some of the defense teams are housed in a foreign ministry, some are housed in a justice ministry, and then some are housed in a trade or economic ministry. And I think, in terms of sort of the initial establishment of the team, this is important because it reflects both, in some sense, the priorities of the government and how they're looking at dispute settlement, but also the kind of experience that the team is naturally going to bring, right? So a justice ministry will presumably have experience in litigation. Depending on the justice ministry, maybe less experience in foreign policy and diplomacy. If you go with an economic ministry, they obviously will have a lot of experience with economic instruments, with the treaties that might be at issue, perhaps different kinds of experience in litigation. And obviously the foreign ministries, efforts are primarily focused on foreign policy and diplomacy. So however it is that you construct it, you need to think about where it is, what the emphasis is, and then what you have to do to build around that particular experience. So in our case, ours is at the Foreign Ministry, the State Department, and that means that, we are building the team out by hiring people with experience in litigation, in public international law, in arbitration. We empower those people to take ownership of their cases, rather than just sort of, at least in our experience, monitoring as outside counsel. Our attorneys are very much sort of in and leading our cases. And then, and I think this is a very important point, we have to maintain a very robust interagency process so that the views of the other agencies and their priorities are all taken into account in our positions. Now, in terms of the history, it's actually fairly interesting. It goes back to 1981, just as actually our first treaties were being negotiated, but it isn't ISDS specific. It actually has to do with one of my other previous hats, which was the Iran U.S. Claims Tribunal. So in 1981, there was actually a question about which agency would represent the United States, particularly in the government-to-government claims at the Iran U.S. Claims Tribunal. And ultimately, that question was resolved by Edwin Meese, who was then the counselor to President Ronald Reagan. And the determination was made that it would be the State Department. And the reason for that is, there were several reasons, but two big pieces of it were, one, historically, the State Department represented the United States in interstate disputes. I mean, for those of you who know this history, it goes all the way back to 1794 with the Jay Treaty, but all through the 1800s and the early 1900s, when arbitration was regarded as kind of a species of diplomacy, all of that work was done by the State Department. And second, it was recognized, at least with respect to the Iran Tribunal, that there was kind of a foreign policy element to it. And so there should be sort of State Department lead representation on those matters. So then jump forward 17 or 18 years to the Lowen matter, and it made sense that the State Department would continue that work. And again, a variety of reasons for that. One is, as I'm sure many of you know, a lot of the work at the Iran U.S. Claims Tribunal ended up being highly relevant to those early, particularly early investor state cases. The Iran U.S. Claims Tribunal had created a body of published law, and a lot of those early cases drew on some of those publications as authorities or at least sources subsidiary means, however you wanted to look at it, for some of the principles that would have to be applied in those early cases. Now, I should note, of course, that in Lowen, we were co-lead with the Department of Justice, and I think there was maybe one other case after that. But ever since then, since the very early 2000s, the office that I work in, and one of my colleagues is here too, the Office of International Claims and Investment Disputes, has been lead in ISDS. I will say just one more word quickly about how we develop expertise. And the main way we do that is, frankly, by being involved in active cases, which means that our office does not do solely ISDS. We do work at the International Court of Justice. We do international commercial arbitration that may involve the United States as a party. We work on espousal or diplomatic protection cases. We serve as agency counsel, as counsel for the State Department in cases involving that involve some of our equities in domestic courts. So we have our hands in a lot of different kinds of litigation and a lot of different fora, and that enables us to stay very active, to hone our skills, particularly as we're developing more junior attorneys. And this was particularly important when the ISDS portfolio was not active. For better or worse, in the 3 years that I've been chief, it's been very active. But we still have all of those other cases. So we stay a busy office, and most of our training is actually through Do It.
One short follow-up question. I might know the answer, but it's also important for everyone to understand. Do you also provide any supporting legal work in negotiations of investment treaties? And does that also, in a way, keeps the team busy?
Well, the United States hasn't negotiated a treaty since the USMCA, and before that, there was a little gap. So it's not currently, a regular part of our work, but when treaties are being negotiated, yes, we have, I think the way you described it, is a supporting role. So the U.S. Trade Representative negotiates our free trade agreements that have investment chapters. The State Department would probably take the lead on a bilateral treaty. Our office is consulted on those matters, and yes, we stay involved.
Thank you, María Carolina. Any comments on that, on what David has shared with us?
Sure. I mean, I don't know the history as David does, but I want to highlight a couple of things that he said that applies, I think, not only to the model that the US has adopted, but it applies also to other models of defense. Going hybrid, which we will talk more in detail later on, but also for the governments that use only external counsel. I think, David, you mentioned one point that was of particular interest, I think that applies to everyone, is the robust interagency process. Because usually none of these cases involve only one agency. They usually involve multiple agencies, the agency that gives the concession contract, the agency that regulates the land, the agency that regulates some other part of the investment. And I've had cases where you can really tell, and it goes into the result of the cases, whether there has been real coordination in the good sense within the state, within the interagency, because, and you really need a lead agency to handle that, whether it's the State Department that it does all the in-house work, or whether it's on a model like the Peruvian government that they hire external counsel, but you need one agency leading all of that so that you can, in the end, explain to the tribunal that everyone was acting in a non-arbitrary manner and in accordance with the rule of law. And that's not as easy as it sounds sometimes, because some agencies are acting within their own interests, which investors can exploit at times and saying, no, this is completely arbitrary. They are contradicting themselves. So it's the task of that lead agency, and then if there is external counsel, to communicate that to the tribunal. And so it's coordination to win a case.
Thank you, María Carolina. And since you brought the model of Peru into focus, I would like to welcome Jean-Pierre Galvan and also Mijail Cienfuegos, who are with us from Peru. Not sure whether you're sitting side by side. You might or you might not, but you're both with us, which is a good thing. And one question that that really comes to mind for us to understand how how special is the model of Peru is. There's many things to be said, and I believe positive about Peru. One is it's one of the few countries that do have contracts that have the exit clause. Not many embrace that possibility. However, interestingly enough to me, and these are my own comments, other countries embrace other arbitration clauses, being ICC or AAA, etc. So in general terms, that's sort of in the world landscape. But Peru includes exit cases in PPPs, and I would like to ask Jean-Pierre, how does that work? How has that impacted investor state or international arbitration disputes? And then we'll ask other questions to Mijail. Jean-Pierre, do you want to take the floor? And we might have a slide for him, which we're about to put on the screen. Yeah, there you go. There it is.
Can you hear me?
Yes, we can hear you, and we're trying to make it bigger. And I'll be
Okay, I will wait.
yes, there it is. Lovely.
There it is.
Yes.
Well, first of all, I want to thank you to invite us for this very wonderful event. My name is Jean-Pierre Galvan. I have the honor of serving as president of the special commission that represents Peru in international investment disputes. Preliminary today, I will briefly highlight the evolution of Peru regulatory framework for concessions, a story that reflects our nation's commitment to transparency, competitiveness, and sustainable growth. This process began in the early 1990s when Peru opened its infrastructure to private participation through public and private partnerships. It was a decisive move away from a state-driven model, allowing investment in energy, transport, telecommunications, and laying the foundation of modern contracts. But the late 1990s and early 2000s, the creation of pro-inversion and specialized regulatory bodies gave a structure and predictability to concession system, essential to attract investors and ensure public benefit. Then, in the early 2010s, Peru took a major step by including ICIT or CIADI arbitration clauses in its PPP contract. This measure created a scenario of confidence for international investors, guaranteeing neutrality, legal certainty, and fair dispute resolution under international standards. It strengthened Peru's reputation as a reliable and responsive partner in long-term infrastructure projects. In recent years, our focus has expanded toward digital transformation, climate resilience, and community engagement, ensuring that every reforms contribute not only to economic growth, but also to social inclusions. And this evolution connects directly to our next topic, that is the international dimension of investment disputes. To explore this further, it's my pleasure to invite Mijail Cienfuegos, who will discuss Peru's experience with investor state dispute settlement, or ISDS, and its role in balancing investment confidence with state sovereignty. Thank you very much for.
Thank you, Jean-Pierre, and I'll also smooth in part of our questions to explain how does the commission that we have referred to works. It's the investor state arbitration commission, or the commission that oversees the disputes in Peru, and both have experience in this commission for everyone to understand better the model there, given these disputes, but also given which may be contractual disputes, but also disputes that may be solely based on treaties. Mijail, welcome.
Hi, can you hear me well?
Yes, we can.
Thank you very much, Pierre, for giving the floor. Thank you, José Antonio, for the invitation to this panel and for the kind introductions. It's a privilege to be a panelist alongside David, María Carolina, and Mallory, and I look forward to seeing everyone in person soon. Before I begin, I should say that the views I express are my own and don't necessarily reflect the position of the state. I'd like to start my presentation with a brief introduction to our defense system, the Peruvian defense system. Law number 28,933 established secrecy in 2006, which stands for State Coordination and Response System in International Investment Disputes. Its main objective is to optimize coordination and response within the public sector to handle international investment disputes efficiently and effectively. Secrecy is composed of the coordinator, the special commission, and the public entities that sign agreement with national or foreign investors, guarantee rights and guarantees. That represents the Peruvian state international agreement with investment-related provisions. And when it comes to representation, the Special Commission is the body that represents Peru in all stages of the international investment disputes. It's an interagency collegiate body chaired by the Ministry of Economy and Finance. And also, the Special Commission may also include each public entity involved in a dispute as a member of this Special Commission. The work of the Special Commission is supported by the Technical Secretariat, whose core functions include conducting the initial assessment of disputes, preparing reports and strategies, and providing all the information needed for the Commission to perform its duties. In response to your question, José Antonio, about how central the Special Commission is to preserve technical aspects of management investment disputes, I think both the Special Commission and the Technical Secretariat are indeed central to Peru's defense system under secrecy. The Special Commission coordinates the interinstitutional defense from the early stage of the dispute, ensuring timely monitoring, centralizing information, and involving the relevant public entity in decision making. Meanwhile, the Technical Secretary provides continuous technical and administrative support, ensuring the effective management of international investment disputes. And I think that answered this question.
Thank you, Mijail. One follow-up question which came up during our panel preparation, and so going back to María Carolina's point about the coordination, clearly the Commission is the coordination entity that facilitates having one position of the state in investor-state arbitrations. That we understand, but then given that Peru outsources its cases or its defense to law firms who specialize in investor-state arbitration and public international law, one key question is, how does the Commission ensures that the state from case to case maintains certain consistency in key positions? For instance, that they don't say, well, this is an example out of my head. I'm not saying that Peru says that, but let's say, that in one case they say, well, we believe that legitimate expectations doesn't exist as part of customary international law. And in other case, external counsel says, well, we think that it might exist under this condition. So how do you ensure consistency from case to case when you're represented by different counsel? That's one question. I have more, but I won't abuse your kindness.
Yeah, well, it's not secret that Peru works alongside several international law firms. For example, Baker Botts under the leadership of María Carolina and Jennifer. But returning to your questions, in my experience and in the context of working with several international law firms, consistency in the state's position is only possible when there is an ongoing dialogue between the firms, the Special Commission, and its technical secretary on the specific issue like legitimate expectations to be addressed in the international investment dispute.
Thank you. Mallory, any comments?
Well, first of all, thank you for having me. It's lovely to see everyone here at Washington Arbitration Week. I guess my caveat should be that I have never held a position in government, so I am speaking from that perspective. But I have worked with quite a number of states, and as I was listening to everyone, some of the points that jumped out at me are, first of all, that each state is different. Each state is differently situated, and each state comes to international investment law at a different point in time, from a different perspective, for different reasons, with different objectives. So it was really, really nice to hear some of the representatives who I know are speaking in their personal capacities, but explain that historically, the way that their programs were set up was done in an organic fashion, responding to a need over time. David was saying earlier, well, this is why we were set up in this particular way, because of things that were happening in 1981. And that does seem to be how it happens in the real world. It's very, very difficult to try to anticipate in advance all of the different twists and turns that can come up over the life of a state's involvement in international investment law and in ISDS. So the fact that states are going about this step by step, responding to needs organically, I think makes complete sense. I also really like the question about what to do on this issue of consistency, because it's one that probably wouldn't have come up 15 years ago. There were a lot fewer states that had very developed in-house teams that were managing this sort of issue. And it was also more infrequent that the pleadings in cases would be public. So for someone to assert that there was an inconsistency in positions taken by the state in various cases, they would either need to guess somehow or use a published award and extrapolate from the summary of the parties' arguments that a state had said X or Y, and then attempt to attribute that position in a binding fashion to the state, which didn't always work. So I think it is a really, really difficult thing if you're in the position of managing the in-house team to come up with what is our consistent position. Are we tracking all of these things in the various proceedings, not just on merits issues, but potentially on procedural issues that can come up as well? And I think it's a matter of coordination and tracking and dialogue with your external counsel, just staying on top of everything to the extent that you can.
Yes, please go ahead, David.
I just wanted to underline that it's not just consistency in ISDS. One of the benefits the United States has and our office has in seeing things across different fora, but also our very important interagency process, is that some of the ISDS issues are not specific to investment. So things like how we use the Vienna Convention on the Law of Treaties, things like, a necessity defense, for example, could pop up in trade. And that's in the US government that's led by USTR, not the State Department. There could be other issues that come up. The sort of interpretation of the ICSID Convention is obviously relevant to what we do, but it's also relevant in certain actions in domestic court that the Department of Justice is going to head up for us. So staying consistent across platforms becomes very important as all of these decisions are public.
Wonderful. Thank you, David. I mean, also putting the emphasis on the issue that it's not only investor-state arbitration, as you say. Now let's look into some black and white comparison and an opinion about the advantages and perhaps disadvantages of embracing one or the other model. And that question would go to María Carolina. So the question is, what might be the advantages of having an in-house full defense team, and what might be the advantages of having the other model where you're hiring experts on investor state and public international law?
Thank you, José Antonio. And I should start, I didn't say it before, but thank you so much for inviting me. It's always a pleasure to be part of Washington Arbitration Week. And it's lovely to be at your offices. But of course, how you organize, how the state organizes or what model it adopts to defend the state is absolutely key. And it can be a make or break system, especially if you're not as experienced as the US or Peru with many cases, but when you first receive the case, oh my gosh, what do you do? So, I mean, states do need to sit down at some point organically to define what they want to do and how they want to handle it. Before going into the model in particular, I would have to say that it's absolutely key, and sometimes it's not considered, but it's absolutely key to have an institution, an agency, a commission, or some sort of institution that it's outside the political world, that it's in charge of defending the state, because normally these cases span multiple administrations. And it has happened to me when defending states that the administration changed and the opposition comes in and it's all the fault of the previous government, and now I don't want to defend anything. And we need to work very closely with the government and tell them, no, we're defending the state, the republic, or the state in general. And to achieve that, creating some states have started to create something similar along the lines of what Peru has created, but certain institutions that are more technical, that handle those cases and decide what model to adopt. So of course there are advantages of hiring external counsel. Why wouldn't I say so? I usually act as external counsel, but I mean, the main advantages is you get a big team with expertise and experience that can handle very complex cases, and you have the full muscle of a firm that has handled cases. And not only that, but they know the arbitrators, they know the opposing counsel, they know what type of arguments they will present. So all that know-how, the state, if they're just starting, they don't necessarily know it, no? And it could be efficient in a way if it's handled well. And the state sometimes can gain some type of credibility because it's not there. Not that in-house doesn't have credibility, please don't consider that. But I mean, having a third party, external lawyer could bring credibility, especially if they know well the arbitrators and their arguments are going to be received with respect. The disadvantage, of course, is the cost. It's no mystery, law firms are very expensive. So some states might not be willing to take on that cost. But I want to go a little bit more into the hybrid model that we haven't discussed at all. Because nowadays there are some states that are trying to develop that hybrid model and they want to eventually go into the in-house model. And the hybrid model is basically the external counsel works with the in-house counsel, but the in-house counsel is not only a coordination agency, but they actually do part of the work in the defense of the state. And that's all great. States should develop their own in-house counsel, and eventually if they do receive lots of cases like Spain, it's happened to Spain, it happened to Argentina, they eventually need to organically move into the into the in-house model, but it needs to be structured very well because it can be very risky. I have seen states nowadays that they decide in the hybrid model that they do the first portion of the case without involving external counsel at all. So they receive, of course, the notice of arbitration, and from that they select the arbitrator, they constitute the tribunal, and they also do the first session with the tribunal without involving external counsel at all. But then they ask the external counsel to do everything else. And so that's great if they can do that. But the strategic decisions that happened in those very first stages of the case are key to the rest of the case. So I would advise to, even if the in-house counsel does most of that work, to at least consult with the counsel that you want to work with later on. Conflicts with the arbitrators, for example, and the external counsel can do a very deep due diligence on the arbitrators and that you want to select or not. The procedural calendar is another matter. And then all the strategic decisions on how to handle witnesses at the hearing, how to handle experts at the hearing. Those decisions are made at the very beginning when you don't know much about the case, but they need to be taken very carefully. So it's a great model, and it's a model for the state to work along the external counsel that has all the experience, and they can learn from the practices how to be most efficient or not. But it needs to be handled in a manner that they both work together, I would say, since the very beginning. Perhaps you save costs by letting your external counsel say, no, I will handle this, but please advise me on certain matters. And then you can work together. And then eventually they can move into the in-house full model, which could work very well.
Thank you very much, Maria Carolina. And, given the prerogatives of a moderator, I might take a slight turn or focus on this hybrid model. I see some non-verbal language, and like really wanted to talk about it from all of our panelists. So I would welcome your comments, and I'll make a set of questions that you have touched upon. I would welcome, of course, Mijail or Pierre to share their views on the hybrid model. Not that I'm suggesting that Peru is thinking about this. That I don't know. But I think that there's a reason why Peru stays in the model that outsources the cases on defense in investment arbitration to outside lawyers. So one question to them is why Peru is sticking to its gun and say, no, this is our model and we're happy with it. That's one question. But to touch upon Maria Carolina's points, I would also like to ask everyone here. I don't want to put anybody on the spotlight. How important are those initial steps that Maria Carolina referred to, and could they simply be done by in-house without the experience? Because that is something that we're seeing in some of the defense teams around the world. There's the notion that we can, with a few calls we can appoint the arbitrators. I mean, is that something that is done? At least in my experience, we would do a deep research as to the whole line of decisions of this or other arbitrators. I also take when Maria Carolina said that we know the arbitrators, doesn't mean that they know them. They know them professionally. They know what they have done. Their names are known. I don't think that she meant I know them, but I know what they have done in the past, and they know my name because I have appeared in other arbitration. Is the procedural order. We will have a full session on procedural order, but just those two questions for the table, starting with Mijail on the risks and on any comments of what Maria Carolina has said.
Sure. Yes, I agree with Maria Carolina. but I just have a brief comment on the hybrid model. In my view, this model is only efficient if hiring an external law firm does not appear as a remedy to solve problems that may have arisen during a stage handled exclusive by the in-house team, as María Carolina mentioned in the context of the procedural order or appointing arbitrators.
Well, that was very to the point. Thank you, Mijail. But the message is clear. Mallory, you want to take the next
I
one?
think the thing I would add to that is it's not just a matter of having this strategy from the beginning, as everyone has explained, but a matter of implementing it throughout the case and potentially over the course of many cases. Because it may be that in the first case that you're working on in your brand new in-house unit for defending the state, you only have certain jurisdictional issues that you get to, and you don't get to the full panoply of procedural matters or merits issues or damages questions that can ultimately come up over the course of many different cases in investment arbitration. So thinking about if you are moving toward a hybrid model, thinking about how to do it over the course of many cases, deciding at the outset, for this case, we are going to work with external counsel. For this other one, perhaps it's a smaller case. There are more issues of domestic law. We have now had sufficient experience working with law firms with many different perspectives, and we think we can do this one. Thinking about that from the beginning can be very useful, and then using this existence of many cases to your advantage to slowly acquire all of the information and expertise and experience that you'll need to take things on completely by yourself is, I think, one of the better ways to do it.
Thank you, Mallory. David?
Again, just a very quick point. I think it partly depends on who you have internally and the kind of experience that those people have. I've seen some very successful hybrid models. I mean, just, we know our colleagues in Mexico, for example, they largely run their cases, but they do hire external counsel to assist and advise. But I don't know for sure because I'm not monitoring day to day, but my sense is that they are running the case from beginning to end. But they have the experience and personnel to do that. So I think it really depends on, and of course, we do everything internally because we have that experience and personnel. Many of the people that come to work at the State Department are coming with experience. And so it's not even developing the experience entirely in-house. I think to the extent that states are looking to transition to a more hybrid model, it may start with seeking out those people as hires to help. And then, as other panelists have said, then it's, I think, an iterative process over time by which, the in-house team takes more and more as it develops that experience.
Thank you, David. So it can be possible, but being a thoughtful process. Now, I want to turn to Mallory.
Do you want the answer to the procedural question too?
Oh yeah, just go ahead. Yeah. The answer to the procedural question and the answer to how is it just a few calls just to see is it a decent arbitration, or is it the standard of the exit convention is basically that it be a well-reputed individual that has a good reputation, but there's no substantive requirements. It doesn't even need to be a lawyer. It can be an economist as long as they would be impartial and there would be no bias. But is that the length of the examination that lawyers should be doing when considering arbitrators, or where should you go? We simply have said, of course, do you know him? Oh yes, is he impartial? Or how deep should it be?
Well, so on the question of why procedural order number 1 is so important, to me, it comes down to case strategy. These are huge cases, just massive, where you are trying to marshal all of the evidence, the witness testimony, the expert testimony, the exhibits, the authorities, the legal arguments, potentially on every single issue that could come up on the case, and do it within a procedural context that can get tricky and complicated because it's flexible, but you want to work that to your advantage. And so you need to go into this whole process with a strategy that you then implement over a period potentially of years. And you implement in everything from the opening lines of your opening statement to the teeny tiny footnotes in your written submissions or in the procedural correspondence that you send. And you need to have that sense of what your case strategy is going to be at the outset in order to implement it. And then you can go about taking advantage of the various tools that are available to you, which include many of the options set out in procedural order number 1. So there are questions about things like bifurcation that can arise, or the procedural calendar, whether the witnesses or experts are going to give any direct testimony at the hearing, or if they're just going to be cross-examined, when the hearing is going to be. So all of those things are very, very important. They set the stage for the case, but you can't do any of it unless you have a strategy to begin with. So it does take a lot of time at the outset, not just researching arbitrators, but understanding the case, what you're dealing with, understanding the other side's case as well, and then coming up to the extent that you can with a global strategy and working backwards to find the steps that you should take.
And now, again, under the prerogative of the moderator, I would simply like to share that as Mallory has indicated, there are profound issues that go also beyond investor arbitration. Things that are decided at the beginning, such as language. There might be a reason of sovereignty concerning the language that you choose. I remember that one of Mexico's chief arbitration defense lawyers 20 years ago, whenever he was appearing in investor state arbitration, they, as a matter of language sovereignty, they would always speak in Spanish. And yet in the conferences, he has the most impeccable English that you could hear, and he writes in English, but there are key issues that the state may want to consider as a position there. Also, every arbitrator has its line of decisions, and you want to know what they have decided. And one of the beauties of investor arbitration is that the decisions and the awards are more and more out there, available to the newer treaties allow a lot of transparency in that sense. Not everything is public, but there's a lot of data to research. A call might be important, but it doesn't do it. With that, I'm also aware of time, but we're in a good place still. I would like to ask Mallory now, with all this information, if a state is considering either an in-house model or a transition through a hybrid model, how can the state? I mean, let's say that they have done the best they could with the hiring process that David is suggesting, but at some stage they go, well, we need to accelerate this process. And how can we facilitate or accelerate the process of strengthening the in-house team? 20 years ago or 10 years ago, there wonderful workshops by UNCTAD, which rely a lot on the substance. So what are the 4 elements of jurisdiction at ICSID? What are the substantive obligations? Is that sufficient, or do we need a different type of training? What kind of training do in-house counsel need, etc.?
So one of the things that, as I was thinking about this, may be overlooked is that in addition to having the in-house team that is directly responsible for the defense of states in these cases, you also need to have other people within the government who can assist you. This is an interagency process, as all of the government officials or former government officials around me have explained. And you need to be able to help your colleagues to help you or have them in a position where they can help you. It's not just a matter of ensuring that the people within the one government unit directly responsible for the defense of the state are able to handle all of these tasks. You also need to have people in other parts of the government looking out for these issues so that they can perhaps flag for you that there may be a dispute percolating somewhere and they need a consultation. You would need them to know that at some point you may call on them to speak with you or with external lawyers and eventually sit as a witness in one of these cases, or that at some point you may come asking for documents to prepare the defense of the state, or because the other side has requested them in document production and the tribunal has made an order. So looking beyond just the individual government unit to the other agencies is very important. And I mention that because it's also a way that members of the particular unit are able to improve their skills. Every time you have to answer questions about what it is that you do, what could come up in these cases, you are improving your own knowledge. You are working on your advocacy, able to crystallize these points in your mind and also in the way that you convey them. So working within your own government to help build up a system that will make your job a lot easier will help you in the long run, not just because it makes the job easier, but because it helps you to improve your skills. The other thing I would consider is that there are so many people in the world nowadays that know about investment arbitration, and this wasn't always the case. Now there are so many people with, advanced degrees in the subject, and they are just looking for jobs everywhere in the world. So it may be that you have that capacity somewhere within your own state, but if you don't, you can also consider bringing in a foreign national with significant experience to run the government program, as many governments around the world have already considered doing, and some have done with great success. So think about the people and what you want your program to achieve, and then go from there.
Thank you, Mallory. David, any comments on that?
Sure. I mean, so certainly Mallory has given this the most thought and careful consideration, and I thought that her talking points were really insightful. On the looking to other agencies, I can just speak, or looking, to educate other agencies, I can speak to our experience. We had a case in the mid-2010s, actually 3 cases, all by the name of Apotex. And our client was the Food and Drug Administration. And I can tell you that we did a lot of education at the Food and Drug Administration about what this process was and what it meant. And I agree with Mallory. I think it helped us not only sort of improve our presentation skills and our understanding when we have to explain it, our understanding of the substance to this other agency, but it also helped us, I think, in the process of developing the case. I mean, we had invested clients who now understood what we were trying to do, and we had to understand how what we were doing fit into, their mission as well. The only other thing I might add to the points that Mallory raised is sort of the partnership between the state and its law firm. I understand that some law firms are now coordinating with their clients to bring some of the government officials in-house for a period of time into the law firm, to give them sort of that day-to-day experience working on the litigations. And I do think that that's a very valuable experience if law firms consider doing that more to help states build capacity. Because, I mean, for better or worse, I say this as somebody who spent 9 years in private practice before I joined the government. I mean, my government experience has been unbelievable, but there may not be many experiences like, having to work, those hours at a law firm at that very, very high degree of perfectionism. There are many unhealthy things about it, but you certainly do get a lot of experience in a very short period of time.
Thank you, David. I mean, I couldn't agree more with that. Well, yeah, there needs to be some balance.
Yeah.
Now, I think this has been
Can I
María
just
Carolina,
say-
please go ahead.
Sorry, very short because I know time, but I fully agree with what everyone said. But I would also add that it's important to do training sessions, not one training session every 5 years, because government officials change.
Yes.
And even if you have this dedicated team that is going in-house, I mean, they have other offers, they want to go to private practice, so there needs to be a way to build that institutional knowledge that continues ongoing. And so constant training into not only, of course, the subject matter, what the treaty, what are the treaty standards and all of that, but how the arbitration works, what are the procedures, because that also helps the in-house team judge if they're hiring law firms, how the law firm is working. They will start to understand,
Yes.
what they did was good, what this other law firm did was not so good because X, Y, or Z. But having them have that knowledge and getting to know how this world works helps them also better represent the state and better hire external counsel if they need to.
Thank you, María Carolina and Mallory.
So, I agree with all of that because the practice of law is really an apprenticeship model. You learn best from doing, it under the guidance of others and in collaboration with others. But to the extent that you don't get those opportunities right away, or that you don't have a lot of the casework within your own state, just pay attention to what's happening in the field, monitor other cases, review the pleadings if they are available, and go to the hearings or stream them online because many of them are public now, and start to develop your sense of what works and what doesn't work. Watch the arbitrator's reactions when you are there, not involved in the case, but as someone who is completely separate from it, and just hone those instincts, because that will help you when you do get involved back in cases again.
I will say this has nothing to do with training, but just as an aside, one of my favorite parts of my job now is we appear as non-disputing parties, non-disputing treaty parties in a lot of cases. And so I get to go to the hearings and observe the other lawyers. And what Mallory was saying, I mean, still I'm 25 years into practice and still watching other lawyers do their thing. I always find educational, and I think, I should maybe try that a little differently next time. It's great.
No, I mean, that's, absolutely, that's, that happens to me when I read something or when I'm reading a book, and I'm like, how was that constructed? I mean, could I adopt that same way of constructing phrases or this term or that? And that happens also watching arbitrators or other lawyers. It's part of curiosity. I would like to, just finalize by emphasizing some of what María Carolina said about the training, regardless of the model, regardless of hybrid, full outsourcing model or full in-house model. The training is so important because as she said, the client, if it's the sovereign state, will know better what type of job was performed by the lawyers. If they're not trained, then everything goes right. If I'm not well trained, how would I know that they did a good or a lousy job? That's one thing. And the other part is the type of training, and I believe that Mallory touched upon that, that may be more necessary nowadays is a more practical training, getting away, well, not getting away, but you can also learn substance, either through reading a book. I can learn substance, but the issue here is not knowing. The issue here is not about how much I know. I know what Michael Jordan did, right? But can I do it? No, right? So how do you create that muscle memory? And I believe that muscle memory is in everything. I mean, not only in surgeons. Muscle memory is in the experience of doing. How many cross-examinations have you done? 5 or 20? There's a difference. So the type of training that we're trying to build, I mean, at the firm, helping government, etc., is a type of training that is workshop based, specific to the tasks that a lawyer would be doing in performing their investor arbitration counsel job. Document production, you know how to do it, you know how to run it. Cross-examinations, direct examinations. Do you know how to run, do you know how to put together under pressure a closing statement? And that's where the unhealthy part comes, but it is part of the job. Or put an opening statement. All those things are done rather than taught. So, and this, I'll close by this. I teach at Georgetown investor in arbitration, and when with Ian Laird, and when we thought about the model of exam that we would be giving, and we've been there now 13 years, we thought, oh, an essay, right? An essay is a good exercise because it makes you think and so on. But we said, well, no, we'll do something that is practical. And they might hate us or not, but at the end they say, oh, thank you for that exam. It's a 24-hour exam that provides a case scenario, and they have to perform in 24 hours by providing or writing a memo or by writing a brief or something of the sort, because it is that muscle memory that you need. So that's what I would say is the type of training that is necessary to be in any model. And with that, I'll close, but I would like to open for a few minutes questions to the public, unless my panelists want to share any thoughts. Any questions from the public? Yes, please. And do introduce yourself and let me share this with you so that people know you elsewhere.
Thank you. Hi, I'm Mark. I'm an LLM candidate at Georgetown Law, and it's a pleasure to be here. So thank you again. I had two very quick questions. So the first one relates to the fact that in investment arbitration, it is often said that it's quite difficult to reach settlement, especially because public officials may be subject to certain, public scrutiny in their state. And so my question to you would be, do you think that actually hiring external counsel could be helpful in trying to enhancing the chances to reach settlement in investment cases? That's the first question. And then the second question, it really is for countries that are trying to just, be in investor state cases, just relying on internal counsel, but not going to external counsel. How do you attract the best talent? Because to me, when I look at it, you could see law firms paying very high salary and in entry positions, but at the same time, probably the government not doing that. And I think that in the Supreme Court in the United States, I just saw an interview to Justice Sotomayor saying that actually the law clerks make more money than the justices themselves. So there you actually have an incentives. But for countries that are trying to hire the best and the brightest lawyers in law school, how do you do that? Because I understand that you would be paying less than in law firms. So those are my questions.
You have wonderful panelists here to answer. Yeah, and yes, and Jean-Pierre or Mijail, feel free to jump in and share your thoughts. And by the way, I've seen cases where and not only in the US, but in developing countries where associates of law firms say, no, I want to go to the government because it's they might pay me a little bit less, but it's a comparable salary, and they go like, no, I want to have that experience. But that's sort of my experience, but I don't want to answer. Please, anybody can take it.
I'll speak about the first question. About the second one, I'll leave it to David. But for the first question, I mean, it's right on point. It's very hard to reach settlement because in democracies, you have supervising authorities, and it's very hard to reach settlement. Whether external counsel helps or not, it might help, and it does help in the conversation to move forward. But in the end, the decision to settle or not, it's of the public official and of the state. So if the public official doesn't have that authority, or it's a little bit concerned about reaching actually a settlement instead of just acting because they have a judicial decision or an award, in this case, that is telling them to pay an X amount of money to the investor. I mean, it's very hard to reach settlement. But the external counsel, I mean, once the external counsel is hired, the conversation can take a different tone. And so that might help in the conversation. But in the end, the decision is of the client, of the state.
I'll answer the second question. Well, first of all, Mark, I assume you're taking my class at Georgetown, not Jose Antonio's. If you have limited
What about
time.
mine?
Or Mallory's, right? You have.
You can take
limited
both.
choice.
You can take both.
I mean, you know, I left practice as a ninth-year associate and joined the State Department, and you know, yeah, my financial situation is much different. Had I chosen a different path, I can tell you without sort of going into too many details that, you know, we're probably earning less than a first-year associate. There are lots of reasons to do it. I mean, Jose Antonio kind of gave my bio. You don't get that kind of experience in private practice. And it's been, my wife very often says, like, if you had to go back 25 years and tell yourself in law school what you've done, like, I would just be amazed. It's just been sort of a dream. The other thing that I will say is that, and this isn't true in every country, we're lucky that it has been the case for a very long time in the United States, is that there is sort of an honor in public service. I remember just after I joined the State Department, I was invited to speak at an event in Germany, and one of the audience members came up to me afterward and said, like, well, I'm really surprised that you joined the government, because, you know, in our experience here, that's for, you know, parents with young children. Frankly, he said women with young children. So, you know, insulting to me and to women everywhere and to parents. But that's obviously not the case here. And at least in the United States, government service is itself a privilege. And of course, many people do government service for some period of time and then go back into the private sector, and it only helps their resumes. So that's the reason to do it. It's the experience itself, and it's sort of the privilege of serving your government. I have to admit, there's also a tiny bit of like patriotism in it too. And I hope that that's true for people of other nationalities as well.
Yeah, absolutely.
Yeah.
So I just want to add that one of the things to me that is so fascinating and mentally rewarding about this field is that you get to learn about so many different pockets of history. And when Vanessa Rivas left the commission in Peru, she articulated it in this way that I'd always sort of maybe thought about, but it was just so crisp and beautiful about learning about the history of your country, meeting so many people who are working to better it and improve it, and then getting to defend them on the international stage and stand up and say, yes, this is fair, this is what my government did, and I stand behind it, is so, like, such an incredible moment to get to have if you believe in your government. So I think that's a really big selling point.
Thank you, Mallory. I mean, this, now I would qualify that as a practical romanticism, because it is true. It is true. I mean, there's a reason why people go into government, and I was a government official, and I enjoyed it deeply. I would like to give, lastly, the floor to Jean-Pierre and to Mijail for any additional comments that you may have. Jean-Pierre is, has been, before a lawyer and a consultant for in Peru and for many countries, but now he's holding an official position, and Mijail has a deep understanding of arbitration in Peru. So any additional comments that you may want to share concerning the last question as to why serving in arbitration from the state's perspective, and either of you or none of you or both of you.
Just to add one comment about the first questions. When it comes to reaching an agreement, I think it really depends on the kind of solution the investor are willing to put forward. For example, we have cases where investors has asked for the repeal of a law or for multimillionaire dollar payments. In those situations, I think it's really hard to reach an agreement, even with external counsel on a board.
Thank you, Mijail. Any comment and any additional comments, Jean-Pierre? And I'm not pushing you to make comments if you're good, but happy to have you share last comments for this.
I know that in my position is very difficult to make a comment without being in a preliminary state. But I just want to say that the government always want to make the best strategy defend, and will always seek the best law firm to try to reach them.
Thank you very much, Jean-Pierre. We have come to the end of our panel. As you can see, these are some of it are technical issues, but you can also see that there is a soul behind why do we do investors arbitration, why there is a liking for either representing investors or defending states, and it is history.